Welcome back to another episode of our podcast. My name is David Levine, founder and CEO of ResTech Solutions. And today we are talking about AI in litigation, opportunity, risk, and the future of legal advocacy. And I'd like to welcome our guest today, Laura. And Laura, if you'd like to take a moment and introduce yourself.
Thank you, David. Thank you for inviting me. My name is Laura Barbieri. I am the manager and founder of the law office of Laura D. Barbieri, PLLC.
All right. Well, fantastic. Glad you're able to join us today. So, with that, let's go ahead and just jump right into our first question. So, I know from our prior conversation, we talked a bit about AI, and we've actually had a lot of conversations around AI. And I understand that there is a growing conversation that failing to understand or use AI tools in legal practice could eventually be seen as malpractice. So, from your perspective as a litigator, how real is that shift?
Well, I think it is very real. And it's actually coming from the bench because this past January, Judge Jesse Furman from the Southern District of New York said at a New York State Bar Association meeting that he could foresee a day where not incorporating AI into your practice could constitute malpractice. He gave an example, and I think it's a very real and practical one that, for example, if an attorney is doing discovery and bills a client 100 hours for discovery, and that discovery could be done by AI and the technology that's available, billing 100 hours versus billing an hour or two is a significant difference for a client. So I think the bottom line here is that it is incumbent upon attorneys to not only use technology, but understand the technology and how it works. I think that understanding and obligation comes from our model rules, which we have a duty of competency, and that is Rule 1.1. I think that this is not a new thing. This is something that our practitioners are used to. For example, when electronically stored information or ESI came into the fore, we all were familiar with Sedona principles and our obligation to learn about that technology. Similarly, we have an obligation to learn about the new technologies and the capabilities of AI, how it works, and to utilize it in our practice, not to substitute as a human, but to enhance the capabilities and ability for the attorney to meet the client's needs.
All right. No, I really appreciate the insight. And I know you
Absolutely.
also
Thank
operate
you.
in complex litigation and special education law. So, how are you personally using AI in case strategy, preparation, or presentation? So, you operate in complex litigation and special education law. So, how are you personally using AI in case strategy, preparation, or presentation?
I use it quite a lot, actually. So, for example, in employment law, I currently have a case that I'm litigating and it has thousands and thousands of documents. So I am actually asking AI and the technology that's capable to be used to assimilate those documents, to organize them, to create a comprehensive outline, and to preview arguments that I think I'm going to make to the jury and see what the technology says about those arguments and whether or not they're supported by the documents that I've uploaded into the system. I think having said that, we want to make sure that client confidences and the confidentiality around the client is protected because we have a responsibility to do that. But nonetheless, if you redact information or the information is public and has been utilized before, for example, on the docket or has been exchanged between the parties and is not under a protective order, it can be utilized. In special education, I'm using it to analyze what are some people believe are complicated documents, for example, medical records, what is called an individual education program, which is a child's blueprint for how they should be educated, and some other evaluations, for example, a neuropsych evaluation of the child. And using AI to summarize those documents to elicit key points in the documents and to understand them so I can explain it to a layperson. So those are just some of the ways I'm using it. Certainly incorporating it very, very actively into my practice.
Well, great. And I know from many of the conversations I had that a lot of firms talk about AI as a cost reduction tool, especially in the fixed fee environments. But since you don't operate on that fixed fee model, how does AI change your value proposition instead of just your overhead?
Right. Well, speaking of overhead, so you don't want to charge your client for the overhead. Typically, that's not going to be able to be reimbursed for that as a litigator. But it is not just a question of flat fees. But the example I gave before, which is, for example, in discovery, utilizing the technology makes you a more effective practitioner. It enhances your ability to deliver a quality product to the lawyer that you are working with, if you're working with inside counsel or the client, and you can adjust your budget in order to take into consideration the maximum efficiency that you gleaned from using AI tools. So I think that there is it doesn't mean that you're gonna earn less. It actually means you're going to earn more quality money that you want as a lawyer, but also you're going to deliver that quality to the client. And I think that that enhances the value that you're adding to your practice and to your the product that you're giving the client.
All right. Oh, appreciate that insight. And kind of keeping on the topic of AI, and again, I know from a lot of conversations, yeah, I've heard both pros and cons, people for or against AI right now, but kind of knowing what you know with AI and how you've seen it used, what concerns you most about how AI is currently being used or adopted within the legal profession right now?
I think that the concern would be the risk is that you're adopting it without understanding how it works. And so I think that lawyers have an obligation to ensure that they understand what the terms and conditions of the AI tools are, what the privacy protections are, whether the material that they're utilizing is going to be used for the learning capabilities of the system and whether it's going to be stored, where it's going to be stored. All of these questions go to an attorney understanding the technology and it's the way it's used in practice. Those are the risks, I think. Also, to accept the product of AI without questioning its quality. So there are cases already, actually a lot of them, where the research product of the AI tool has been offered to the court without checking the sources. A practitioner, an experienced practitioner, would never give an associate's work product to a judge and have and sign your name to that product as if it was yours without checking every single citation, every single quote, every single principle of law that you were citing. So similarly, you have to do the same thing with a product that is generated by AI.
All right. Well, great. Appreciate that. So I want to shift a little bit. I know we've talked a lot more about the business side and AI, but kind of more you personally. So I know you've talked that you advocate for children with special needs and you navigate the high stakes litigation. So what do you enjoy most about the work that you do?
Well, I've been a litigator for a long time, and I love going to trial. I love juries. I think that when you have an issue, a problem, when someone has a problem, and you trust a jury to make a decision, and the entire process is like being a teacher. You're educating the jury about your case. And in some respects, it's like a performance because you have to ensure that the jury trusts you and the information that you're offering to them. So you have to have a particular demeanor that is going to be, I think, accepted by a wide range of people. I love doing that. I love talking to people. And, when I want to try a case, I talk to as many people as possible to practice explaining the basics of my case so I get people's understanding how they react to it, whether they think it's a difficult case, what the arguments might be against it. It's like explaining it to your grandmother, and you try to make it as basic as possible. And I love doing that. I also love my clients. The people who are in trouble need help, and they are genuinely in trouble. And I think that I want to help them. I became a lawyer so that I could offer a service, and that includes a lot of pro bono work that I do, particularly for students with special needs. These families go through so much to educate their children, and if I can make their lives and their children's lives a little bit better, I feel very, very good about that benefit that I'm offering. So those are lots of reasons why I like my job. I've always liked my job.
I really appreciate the insight. Really speaks to your passion about it.
Yes, I am passionate about it. Thank you.
So, this is probably my favorite question I like to ask all my guests. So, there currently any initiatives, cases, or strategic priorities that you are focused on right now that you're excited about or would like to share?
Yes, I am in the process of writing an article about geospatial technology and its application to what's called attendance boundaries. An attendance boundary is a boundary that identifies where in the neighborhood you're going to go to school. So a school has an attendance boundary around it, and all the children who live within that boundary go to that school. So it's a neighborhood school. So geospatial technology now allows you to look to that technology, look at the neighborhood, and determine whether or not the children with disabilities live within that zone and what kind of services are being offered to those children. If, for example, you're not offering the right tools to the child, there's something called impact. And if the impact is discriminatory against children with disabilities, that you're offering services to non-disabled children that you're not offering to disabled children, you have a discrimination case. So this gives you an incredible tool, and I'm very excited about it. And I think that the article that I'm working on, I hope it will be well received, but I'm still in the process of writing it. So, but I'm very hopeful and I like this tool, and I think it has a lot of promise for not only education law, but also employment law, any kind of law that you want to make an argument that people are being treated differently than other people.
No, it sounds great. I'm always fascinated by how technology is used in areas like this and others, and how it can really help to benefit people in a good and positive way. So actually be very curious to see how that comes out once you have your article finished.
I hope it gets finished soon because I want to move on to something else like trying my cases. But, I have to take a break sometimes and use my brain in a different way. And writing does help me do that.
Great. And so, as more litigation firms begin to integrate AI tools like ChatGPT and others into case prep, what conversations are you having internally about your data security and client confidentiality, as well as hopefully other firms are doing something similar?
Absolutely. For example, if I'm working with my paralegal or I'm working with my legal intern, who are law students or college students who work with me over the summer, I want to make sure that they understand as best as possible what the limitations of AI are. And there has to be a process that they understand that all of their product gets reviewed by a human being. There's always judgment, and the judgment can't be replaced by a machine. You have the human who makes the determination and the judgment, and that's only true if you insist that everything that is generated by an AI tool is reviewed before it's used. So there's a protocol, and that protocol includes the introduction of human beings into the decision-making process.
Kind of my final question for you today. For firms navigating AI adoption, what do you think is the biggest blind spot they're overlooking right now?
Gee, that I think there's a tendency to rely on technology a bit too much. I think that the excitement of this incredible tool sometimes leads us to be making rash or impetuous judgments. And when you read a quality product from AI, and there certainly are some, it sounds great. And not only that, most AI programs are very enamored of you. So they say, this is a great idea. Or, yes, that's just, terrific that you thought of that. And, it has a tendency to be very complimentary of the user. And so that leads less experienced lawyers, I think that their product is correct. And I think that not having everything reviewed and not having them to question the product is a risk. And I think that that's one of the things that has to get built into any kind of law firm or lawyer that's using technology in that way. You have to build in those stopgap measures in order to protect the client and the quality of the work that you're offering to the court.
All right. No, I totally agree. As I always like to tell people, anything AI gives you, I always think of it like a first draft.
Right, right. Exactly.
All right. Well, Laura, I thank you so much for joining me today. Had some phenomenal insights into what you do and especially how AI is being utilized. So I do appreciate it and thank you so much.
Thank you, David. Thanks for inviting me. Nice
Oh,
to
thank
see
you.
you.
You too. Thank you, Laura.
You're welcome. Thank you.